Despite such acts having been enacted, informal workers are not aware of their rights and privileges and therefore are not able to get the benefits of all these laws. This will genuinely protect workers while making it sustainable for businesses also to sustain themselves and flourish. Welcome to the Secretariat. Now we're taking you to the past yet again. And this time we're going to talk about labor laws. This is something that has been very complex in this country. There are many legislations dealing with labor laws, and that's one of the reasons that businessmen find it very difficult to do business in this country. While it is important to ensure workers' welfare, it is equally important to ensure that labor laws do not prevent trade and industry from functioning efficiently. What has happened in this country is that the multiplicity of laws regarding labor issues have created complexities, and these have affected the very survival of enterprises, whether they are large, medium, or small units. This all began 7 months after independence, when Parliament enacted the Minimum Wages Act in 1948. It laid down that central and state governments would lay down wage standards rather than leave the issue to market forces. The focus was on protecting living standards of workers. This was a well-intentioned move, but it created challenges because it was part of a larger network of labor laws. The Minimum Wages Act had followed an earlier legislation, the Trade Union Act of 1926. This act was framed to empower workers to form unions and negotiate terms with their employers. Yet another law, the Industrial Disputes Act of 1947, helped unions to mediate wage disputes. It was much later in the 1970s that two more labor laws were enacted. One was the Equal Remuneration Act, and the other was the Contract Labor Act. The Equal Remuneration Act ensures that the same pay is given to men as to women. And the Contract Labor Act ensures that employers pay fair wages. And in case of any dispute, the primary responsibility is that of the employer. Despite such acts having been enacted, those in the informal economy are not aware of their rights. And these privileges are only available to those in the organized sector of the economy. Informal workers lack union representation, are not aware of their rights and privileges, and therefore are not able to get the benefits of all these laws. For small businesses, on the other hand, these very same laws are so intricate that it tends to overwhelm them and they find it difficult to implement them. The fact is that both center and state can lay down minimum wages, and as a result, there are as many as 1,500 wage rates in the country. With such complexity, it's no wonder that foreign investors say that it's difficult to do business in this country. It should be possible to provide a fair deal to workers without creating so much of red tape for entrepreneurs. An effort has been made finally to streamline these laws into a more cohesive framework. This will genuinely protect workers while making it sustainable for businesses also to sustain themselves and flourish. The 29 central labor laws have been consolidated into 4 codes, and these have been passed by Parliament in 2020. But it's taking a very long time to get them notified because they have to be approved by each state one by one. But the outlook for bringing simplicity into the labor sector is definitely much brighter than ever before. The new codes are likely to come into operation gradually as each state operationalizes them. This should iron out many of the complications that have beset workers' welfare and management in the past. The modernized systems will also cover a new category of workers that we all know about nowadays, the gig economy. So it should be possible to protect workers' welfare in a much broader sense than ever before. Not only that, it should be possible to provide for the welfare of workers as also to ensure ease of doing business. That's it for now. Thanks for watching.